Consider this scenario. You believe you suffer from a mental health condition related to service, or maybe even another service-connected condition. You've never been formally diagnosed with a mental health condition, so you're not sure what condition to put on the claims form. You hear everyone talking about PTSD, so you just put PTSD in the form. You go to your C&P exam. The C&P examiner says, well, you don't have PTSD, you have depression, but I do think it's related to your service. Despite the positive nexus opinion, you're still denied your claim, with the VA saying, well, apply for PTSD and you don't have PTSD, you have depression. Welcome to VA Made Easy. I'm VA-accredited attorney and U.S. Army combat veteran Ed Farmer. Today we're going to discuss that scenario where you apply for one mental health condition, but you're denied because you're diagnosed with another mental health condition. I'm going to give you some case law you could use to get that overturned. If you've been denied your VA claim, visit me at vetlawoffice.com. I provide zealous advocacy. I'll prep you before your C&P exams. I have legal investigators to help you get buddy statements, and I have access to VA medical nexus opinions. Sign up for a free consultation at vetlawoffice.com. But for now, let's get into it. So when you apply for service connection, generally you want to apply for the diagnosis that you have. However, when it comes to mental health claims, you may not know what that diagnosis is. Maybe you were never formally diagnosed. You've never gotten treated before. Maybe you just know what the symptoms are. It would be devastating to many veterans' claims if the VA could deny you a mental health claim just because the diagnosis you put on the claim form is different from what the C&P examiner says you're diagnosed with. Fortunately, there is some case law you could use to combat this. There's a case called Clemons v. Shinseki. I'll put the full site up here on the screen in case you want to read the case law. But essentially what Clemons says is if you apply for one mental health condition, the VA has to consider that a claim for all mental health conditions that are reasonably raised by the record. So in other words, just because you claim PTSD doesn't mean that your claim can be limited to PTSD. The VA has to consider other mental health conditions. And the reasoning behind this decision in Clemons is the court said veterans and their representatives aren't competent to diagnose mental health conditions. You need a mental health professional to diagnose you. So this holding sort of gives you some leeway to prevent situations like I described in the beginning, so you don't get denied just because you don't know what mental health condition that you have. So how can you use Clemons to help win your claim? Well, one, if you were denied for having the wrong diagnosis, Clemons could help you get that overturned. So again, I see it all the time. Even despite this court ruling, the VA will still deny a veteran because they applied for a different mental health condition than they were actually diagnosed with. That's the wrong move, VA. So if that happened to you and you still have the positive medical nexus opinion and you're able to prove the in-service event, and the only reason they denied you is because you put down a different diagnosis than you're actually diagnosed with, then I suggest doing a higher level review. If you've been denied within 1 year, do the higher level review. VA Form 20-0996. Request an informal conference. Point out to the higher level reviewer, hey, there's this holding in the case called Clemons. It says just because I apply for one mental health condition and get diagnosed with a different mental health condition, you can't deny me on that basis. You have to consider a claim for one mental health diagnosis to be a claim for all mental health diagnoses as long as the symptoms are reasonably raised in the record. If the higher level reviewer knows what he's doing, he should overturn that decision. How else can you use Clemons? Well, to prevent needing to argue Clemons in the first place, when you're filing the new claim, I would not limit your claim to just that diagnosis. Unless you're positive, yes, I absolutely have PTSD. I know it. That's what my psychologist said. I think the better move here is to file for any and all mental health conditions. And then what you want to do is you want to list the symptoms you are experiencing. So I have depression, I have anxiety, I have sleep issues, I have panic attacks. That way, the VA will consider all the symptoms described and they'll go off the diagnosis from the C&P examiner instead of limiting you to what you put on the claim form. To summarize, you don't need to put the exact mental health diagnosis on the claim form when you're filing for service connection for a mental health disorder. The holding in Clemons protects you. A claim for one mental health condition is a claim for all mental health conditions. When filing, focus on the symptoms and not the diagnosis. And that does it. If you guys need help with your mental health claim, visit me at vetlawoffice.com. But for now, keep liking, keep sharing, keep subscribing. And as always, you have the power to change your VA claim.